Ladies and gentlemen, gentlemen and ladies and gents, we have some things going on here. What do we have going on here? I want all of you to pay attention to the fact that we're making a suggestion. I had someone contact me the other day and he says, "Hey, I see your agreement on your website. I see your disclaimer at the end of your emails. Do you mind if I borrows from you?" I told him, I said, "Hey, that junk is up there. You can use it for whatever you need. But when it comes to our disclaimer, you couldn't do better." I said, because not only does that disclaimer appear to be the most fair throughout the entire industry of contracts, because it doesn't impose any obligation on a party unless they violate the terms. It says that the parties will interact and they will be fair with each other. But then if they want to get stupid, if they want to act like they ain't got no sense, if they want to be uncivilized, then it will civilize them. This video is for those who understand arbitration. See, what happens is, and to show you how pissed off they are about us understanding arbitration and using it to our advantage, that's right, you take what they did and you make it better. Now, some of you don't know enough about arbitration to be changing agreements. So if you're going to use this agreement, yes, you're allowed to change things, but do not change the structure of the agreement. Do not change the obligations, because arbitration agreements must be fair. You must understand, it must be fair. You have to understand contract law. So before you decide you want to use this agreement, oh, and by the way, this agreement is dang better than most of them, because I have not seen another agreement that does what this one does. See, if you put an agreement up and somebody sees it for the first time and they don't opt out, man, they stuck. But then, hold on now, make sure you understand. The agreement has to be fair. They have to do something by conduct. So this agreement that was put together was not designed to be unfair. It was not designed to put someone and bind them to a contract against their will. Just anybody, like you, for instance. Those of you who are watching these videos and you just watch them and you say, "Hey, I want to use his video. I want to send it to my friend Tommy." And Tommy, you know what? You can use his video. You can even post comments about the video. You can even post negative comments about the video. Can't slander him. No, no, no. He ain't gonna tolerate you slandering him. But you can post his videos up and you can say, "Oh, and I don't like what he said." No, no. And by the way, he's a stupid mother. You can do all type of stuff like that. He don't care. He'll tell you he don't care. He say you say whatever you want to about him. Okay? Just don't call that mother a piccolo player. That's all he says is do not call him a piccolo player. Sorry, because I am not the man sitting next to the man. Sitting next to the man, sitting next to the man, sitting next to the man who called that mother a piccolo player. So don't call me no piccolo player. But other than that, feel free. Ladies and gentlemen, we're gonna let Dave, you okay, but I'm gonna let Rod. Now we got several voices here. You see all these different voices we done found? Done found some more voices to go with our. Now we have natural speaking 15. I don't like 16 that much. Hey Joey, I don't know. Joey, I think Joey might sound a little bit mechanical. So let's do the young lady. Okay? Joey, you're gonna be all right, but we ain't gonna use you. Hey, you know what? Let's yeah, yeah, let's use Kate. Y'all don't mind, do y'all? Now, what y'all gonna find, and I want y'all to pay attention because it's important. Okay, want y'all, I'm gonna say it again, to pay attention. You see, we got the dark background so that y'all can focus, because we know how y'all like not to focus. Y'all like to put your mind, let it wander. We ain't gonna let y'all wander. I done met wander. Man, she be mean. So stop wandering, cause she don't appreciate you wandering. Sorry. Uh, we gon' we were doing a Google search, and you see how Google's all the way down there. Google can't be all the way down there. Google's got to be up here. So we're gonna take care of Google later. Okay? We're gonna take care of that later. Now, while we take care of that, I gotta pause y'all for just a second. Ladies and gentlemen, as I said in this video talks about the all-powerful use of words and writings, things in all caps, all lowercase, um, word art. When you go into court, certain words that are being used. That video was almost 30 minutes ago that I started putting it up. It's only 52 minutes long. You see, it's going to take 2 hours, and I think that's 2 hours and 40 minutes for it to upload. Originally, it said a little over 2 hours, and it went to an hour and 15 minutes. Now, I need to show you all something so that you understand. And I'm hoping that you all can hear me. Let me go ahead and check this, because this one I'll do over if I have to, because it's necessary. Um, let's see. You see how my voice is so low right there? That's because my headset is not connected to the computer. However, this is not about that voice. So what I'll do is I'll try to talk just a little bit louder, okay? The problem is it's a Mac, and there are two sides to the computer. We have the Mac side and the Windows side. But we're going to come all the way over here because I need to show you all something. You see, I want you all to understand this. You need to understand this because this is important. Prior to my getting the satellite system, I want y'all to understand, because you need to understand. Prior to my getting the satellite system, I was maybe 200 kilobytes in upload and 3 megabytes in downloads. Hold on. Let me show you something. We're just doing a simple speed test. Should be almost 200 because it's morning time. And so the speed is reduced a little bit in the morning time. See, it just went down. It was almost 200 earlier, and we were at 5 upload. Now, y'all not going to understand something, but I'm about to explain it to you. Now, this is a satellite system. Like I said, during the day, that fluctuates. In the morning, fluctuates, but not that much. Ladies and gentlemen, this is enough to have an hour-long video uploaded in 30 minutes. This is enough to have an hour-long video uploaded in 18 minutes, because that was the average. For an hour-long video, I've been testing it out. That was the average. And no, I'm not in Los Angeles. Well, yeah, I'm in Los Angeles. That's where I am. I'm in Los Angeles. Anyway, ladies and gentlemen, my download speed, it's okay. Download speed does me all right. So let me ask y'all a question. For an hour-long video, it's not even a full hour. It's not even a full hour. An hour-long video, why would it take 2 hours and now 10 minutes? It went from 40 to 10 minutes. Has it been 20 minutes? Because what Google is doing is it's going over every word. And it's doing this because it wants to cause frustration. Why? Because I put up a video called Fake News! I used the term fake news. And that's one of the... I didn't know about the algorithm that they actually, would flag videos that talk about fake news. Ladies and gentlemen, all that video does is put up, and look, I use about 20 minutes of a particular TV show, and it's not a copyright violation. Say what? That's right. Ladies and gentlemen, when Google gives you these copyright violations, that's not because they have an agreement with anyone. They don't have an agreement with anyone. What they do is they have a system that will scan through your video and look to see if the material is copywritten. And then what Google will do is it will say, oh, no, no, hold on now, homie. No, 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 hold on. You can use the material. See, the video was found to contain copywritten material. The copyright owner, pay attention, the copyright owner is allowing its use in some countries. But this video cannot be monetized by the uploader. Review the details and dispute the claim if you believe it is an error. Revenue is held separately until a dispute is resolved. Ladies and gentlemen, I'm not a YouTuber. I don't make money off of any of these videos. Go ahead. You'll see that I don't offer any advertisement. The only advertisement I do may be for one of the organizations that I founded. And that's it. Or I may refer you to a particular site or a particular company from a product that I've used that I am proud to say I'm a user of this product. Look at that. It makes your teeth whiter than green. Okay. But other than that, I don't make money off of any of these videos. I don't monetize them. Let's see. The original Eon channel, the one before they took it down, yes, they just took it down because they felt like it, saying that there was a violation of policy, and turns out it wasn't a violation of policy. Then the second Eon channel, they tried to take that down, and I appealed their decision. Then they said, nah, you ain't winning this appeal, mother. That's it. We're taking your junk down. And I wrote them back and I said, oh no, I'm escalating this. I'm appealing your second decision because administrative procedure says that I have that right and you are an administrative organization. Why? Because you're registered with the Secretary of State, which means that the Administrative Procedures Act applies to you. That's right, I did something that nobody else had done. I sat up there and told them, oh no, you're going to follow the Administrative Procedures Act even though you're a private corporation. Wait, private corporations don't have to follow the administrative. Yes, they do. They receive their license from the state because they are creatures of the state, owing their existence and chartered power to the state. And the state must comply with the Administrative Procedures Act. That's why companies must have a grievance procedure and or policy. Turns out they said, you win. No, we were sorry. We made a mistake. You made a mistake. Yeah, we made a mistake. We're going to put your stuff back up. Don't worry about it. So, ladies and gentlemen, now Google wants to continue to play games with individuals like me. I'm not the only one. They just play games. I'm not the only one. Google just plays games. Ladies and gentlemen, this video right here is only 34 minutes. That took 45 minutes to upload because that's, oh, no, no, no. This one took over an hour. Sorry. This is because it said fake news. They hadn't done it with any of the prior videos. All the other videos were just uploaded 10, 15 minutes. Literally 10, 15 minutes of videos were uploaded. But once I did this video, every video since then has taken hours. See, I thought before it was the speed because I was tethering before on my cell phone. So I thought it was because of that it would take 2, 3 hours, sometimes 12 hours to upload one video. That wasn't the case. So, and without any further without any further ado, ladies and gentlemen, we're going to let the disclaimer play so you guys can hear what's going on with the disclaimer. Okay, I'm going to mute myself so y'all can't hear me because y'all don't need to be hearing me. Y'all need to be hearing them. As a matter of fact,
If Respondent S desires the additional 10 calendar days, Respondent must call. If Respondent S desires the additional 10 calendar days, Respondent must cause to be transmitted to the undersigned and
Sorry, got to get it to play from the beginning. So give me a second, y'all. I don't know what Kate doing. She knows we ain't all the way down there. She knows we all the way up here. I don't know. Kate just, Kate just does whatever Kate wants to do. That's what we're looking for. That right there. See how that's what we're looking for. So hold on now.
We will help your strategy get better privacy terms and conditions, immunity of the arbitrator and/or Ian and/or the Ian Foundation. Competency to testify. Attorney's fees and costs. An arbitrator and/or Ian and/or the Ian Foundation and/or an arbitration organization acting in that capacity is immune from civil liability to the same extent as a judge of a court of this state acting in a judicial capacity. B. The immunity afforded by this section supplements any immunity under other law. C. The failure of an arbitrator to make a disclosure required by Section 12 does not cause any loss of immunity under this section. D. In a judicial, administrative, or similar proceeding, an arbitrator or representative of an arbitration organization is not competent to testify, and may not be required to produce records as to any statement, conduct, decision, or ruling occurring during the arbitration proceeding, to the same extent as a judge of a court of this state acting in a judicial capacity. In this instance, the arbitrator acts as a legal representative for both parties with respect to the contract, and is incapable of surrendering, and/or delivering, and/or offering evidence, testimony, and/or records against either client for the benefit of either client or another party. This is a private matter between private parties, and the arbitrator is granted full immunity under all circumstances by all involved parties to include the representative organization associated with the arbitration, and/or their affiliates, and/or their subsidiaries, and/or their parent organizations. This subsection does not apply in the aforementioned such instances. 1. To the extent necessary to determine the claim of an arbitrator, arbitration organization, or representative of the arbitration organization against a party to the arbitration proceeding. Or 2. To a hearing on a motion to vacate an award under Section 23A1, or 2. If the movement establishes prima facie that a ground for vacating the award exists, such shall not have any effect on the original contract, and all parties agree that the arbitrator is free to rehear and to amend the original award if the award is deemed by any organization and/or party to be invalid. If a person commences a civil action against an arbitrator, arbitration organization, or representative of an arbitration organization arising from the services of the arbitrator, organization, or representative, or if a person seeks to compel an arbitrator or a representative of an arbitration organization to testify or produce records in violation of subsection D, and the court decides that the arbitrator, arbitration organization, or representative of an arbitration organization is immune from civil liability, or that the arbitrator or representative of the organization is not competent to testify, the court shall award to the arbitrator, organization, or representative reasonable attorney's fees and other reasonable expenses of litigation. Inclusive comment. Institution of a self-executing binding irrevocable contract coupled with interests. All parties visiting and/or viewing this site and/or contracting with this organization agrees to the terms contained herein and within the framework of this site, that any and all disputes associated with any and all arbitrations will be decided by arbitration, and all parties agree and consent to these terms, and the policies as stipulated within the framework of the policies and procedures of the EEON and/or the Ian Foundation. This agreement shall be construed contractually and not otherwise, and shall remain in effect so long as there is a relationship with the parties, and shall remain binding and irrevocable, as the sole and exclusive provisions and remedy for the parties in the event that there should be a discrepancy, and/or controversy, and/or this agreement and/or challenge and/or otherwise claim, without exception. All parties associated with this agreement are bound by the terms of the agreement, henceforth, forthwith, heretofore. The Threat Outbreak Preparedness Program, aka TTOPP Castle Arms, shall be held as the grantor of the agreement, and the intentions of the grantor shall be held as law of the agreement, and this law as well as agreement shall supersede any and all other laws, and/or associated agreements irrespective of their date, and/or time, and/or mode of creation. Parties recognizing that the arbitration process is a private process, and any and all parties to include third parties are subject to the policies and procedures and the terms of this binding self-executing irrevocable contract coupled with interests. Ian and/or the Ian Foundation agrees to act with respect to the policies as stipulated herein and throughout this site without any attachments and/or adhesions, to due process, the fairness, to equality, to reasonableness, with honesty, without partiality, without bias, without discrimination, without respect the person be they corporation and/or otherwise, to act with complete transparency respecting the parties, with respect the contract, and the rendering of a decision. All parties agree to hold harmless the arbitrator and the arbitration organization, and agreed that the arbitration decision shall be final, no appealable, non-reviewable, that there is a process in place for any cause and/or concern and/or complaint about the arbitrator's conduct, but the arbitration decision is final and no party may review and/or overturn the arbitration decision as agreed upon by the parties in the first instance. The parties agree in substance and in the spirit of the agreement in conjunction with the obligation of contract clause, that this arbitration process shall be outside the scope of statute, that the dispute and/or controversy and/or issue shall consist only with respect to the contract, and that the arbitrator is the only party in a position to judge the terms of the contract as stipulated in the contract. The arbitrator is deemed to have the power of a superior court, whose decisions and/or rulings are not appealable and/or reviewable. The Sitcom Arbitration Association and/or the alternate chosen as a result of the terms of this binding and irrevocable agreement is aware that it is difficult for people to trust their neighbor, to trust a process because the corporate government officials have by their failure deceived and defrauded the sovereign people of the states of the United States of America, as has been placed on the official record by the New Hampshire state government, inclusive of the governor, that is the executive branch, the Supreme Court justice that is the judicial branch, and the general court, that is the state legislature, and the various other courts who have documented that this type of deception cannot be condoned. The EEON and/or the Ian Foundation stands watchful and vows to not repeat the same type of deception, the same type of fraud. In fact, they shall not engage in fraud and/or deception of any kind, and any challenge to their acts and/or actions and/or integrity may only be via arbitration, through the EEON and/or the Ian Foundation, via their arbitration board, and no other venue and/or avenue. The arbitration process shall remain honorable, independent of government, independent of non-private review, as agreed upon by the parties, or subject and obligated under the terms of the agreement. 1. Section A regarding an arbitrator's immunity is based on the language of former Section 1280.1 of the California Code of Civil Procedure establishing immunity for arbitrators. Section 1280.1 was enacted with an expiration date and was not renewed. See also Cal. Civ. Proc. Code Section 1297.119 which gives the same protection to arbitrators in international arbitrations and unlike Section 1280.1 has no expiration date and is still in effect. 3 other states presently provide some form of arbitral immunity in their arbitration statutes. FLA. Stat. N. Section 44.107 West 1995. NC. General Stat. Section 7837.1 1995. Utah Code N. Section 78-31B4 1994. Arbitral immunity has its origins in common law judicial immunity. Most jurisdictions track the common law directly. The key to this identity is the functional comparability of the role of arbitrators and judges. See Butts v. Economu, 438 U.S. 478, 511-12 1978, establishing the principle that the extension of judicial-like immunity to non-judicial officials is properly based on the functional comparability of the individual's acts and judgments to the acts and judgments of judges. See also Corey v. New York Stock EXCH, 691 F2D 1205, 1209 6th Circle, 1982, applying the functional comparability standard for immunity. Antoine v. Byers and Anderson, Incorporated, 508 U.S. 429, 435-36 1993, holding that the key to the extension of judicial immunity to non-judicial officials is the performance of the function of resolving disputes between parties or of authoritatively adjudicating private rights. In addition to the grant of immunity from a civil action, arbitrators are also generally accorded immunity from process when subpoenaed or summoned to testify in a judicial proceeding in a case arising from their service as arbitrator. See, for example, Andrus Compania Maritima v. Mark Rich, 579 F2D 691 2D Sayre, 1978. Granling v. Foodmark and Chem Corporation, 151 F sub, 853 WD. SC. 1957. This full immunity from any civil proceedings is what is intended by the language in Section 14A. 2. Section 14A also provides the same immunity as is provided to an arbitrator to an arbitration organization. Extension of judicial immunity to those arbitration organizations is appropriate to the extent that they are acting in certain roles and with certain responsibilities that are comparable to those of a judge. Corey v. New York Stock EXCH, 691 F2D 1205, 1209 6th Circle, 1982. This immunity to neutral arbitration organizations is appropriate because the duties that they perform in administering the arbitration process are the functional equivalent of the roles and responsibilities of judges administering the adjudication process in a court of law. There is substantial precedent for this conclusion. See, for example, New England Cleaning Serve, Incorporated v. American Arbitration ASIN, 199 F3D 542 First Circle, 1999. Han v. National ASIN of SEC, Dealers, Incorporated, 182 F3D 1014 8th Circle, 1999. Hawkins v. National ASIN of SEC, Dealers, Incorporated, 149 F3D 335th Circle, 1998. Olson v. National ASIN of SEC, Dealers, Incorporated, 85 F3D 381 8th Circle, 1996. Aerojet General Corporation v. American Arbitration ASIN, 478 F2D 248 9th Circle, 1973. Cord v. American Arbitration ASIN, 795 F Sup, 970 ND Cal, 1992. Borix v. American Arbitration ASIN, 205 Mitchap, 149, 517 NW2D 771 1994. Kander v. American Arbitration ASIN, 97 MISC, 2D 267, 411 NYS 2D 162 Sup, CT, Tioga Thai, 1978. 3. Section 14b makes clear that the statutory grant of immunity is intended to supplement, and not diminish, the immunity granted arbitrators and neutral arbitration organizations under any judicial, statutory or other law. 4. Section 14c is included to ensure that, if an arbitrator fails to make a disclosure required by Section 12, then the typical remedy is vacatur under Section 23 and not loss of arbitral immunity under Section 14. Such a result is similar to the effect of judicial immunity. 5. Section 14d is based on the California Evidence Code, which provides that arbitrators shall not be competent to testify as to any statement, conduct, decision, or ruling occurring at or in conjunction with a prior proceeding. Cal. Evid. Code Section 703.5. New York and New Jersey have adopted similar provisions that prohibit anyone from calling an arbitrator as a witness in a subsequent proceeding. NJR Super. CTR 4, 21A4. NY. CTR Section 28.12. Consistent with the protections afforded judges, Section 14d is intended to protect an arbitrator or a representative of an arbitration organization from being required to testify or produce records from an arbitration proceeding in any civil action, administrative proceeding, or related matter. However, if the law of a given state would require a judge to testify in a proceeding for strong public policy reasons, such as involvement in a criminal matter, an arbitrator or representative of an arbitration organization would likewise be required to testify. An exception is made in Section 14d, 1, for situations such as when an arbitrator, arbitration organization, or representative of an arbitration organization asserts a claim against a party to the arbitration proceeding. For instance, an arbitrator may bring an action against one of the parties for non-payment of fees to the arbitrator and may have to give testimony in order to recover. If, in an action by the arbitrator to recover a fee, the other party files a counterclaim against the arbitrator attacking the award, this section is intended to allow the arbitrator to testify as to the arbitrator's claim, but the arbitrator cannot be required to testify or produce records as to the party's counterclaim attacking the merits of the award. Otherwise, the party can circumvent the general rule against requiring an arbitrator to provide testimony by forcing an action by the arbitrator by, for instance, not paying a contractually required fee for the arbitrator's services. Section D, 2, recognizes that arbitrators who have engaged in corruption, fraud, partiality or other misconduct that are grounds to vacate an award under Sections 23A1 and 2 may not be compelled or required to give testimony so that a party will have evidence to prove such grounds. Such testimony or records from an arbitrator are never to be required after the objecting party makes a sufficient initial showing that such grounds exist. A party's allegation of these grounds without a showing of independent, objective evidence should be insufficient to require an arbitrator to testify or produce records from the arbitration proceeding. 6. Section E is intended to promote arbitral immunity. By definition, all suits against arbitrators, arbitration organizations, or representatives of an arbitration organization arising out of the good faith discharge of arbitral powers are frivolous because of the breadth of their respective immunity. Spurious lawsuits against arbitrators, arbitration organizations, and representatives of an arbitration organization or involvement in collateral judicial or administrative proceedings deter individuals and entities from serving in such capacities and thereby harm the arbitration process because of the costs involved in defending even frivolous actions. Parties considering such litigation should be discouraged by the prospect of paying the litigation expenses of the arbitrator, arbitration organizations, or representatives of an arbitration organization. When they are not, the statute enables the arbitrators, arbitration organizations, or representatives of an arbitration organization to recover their litigation expenses and not to lose their fee and incur other expenses in the defense of a frivolous lawsuit. The terms "the other reasonable expenses of litigation" are intended to include both actions at the trial court level and on appeal. A party bringing such suit agrees to pay to the order of the arbitrator and the arbitration organization the full amount of the arbitration award, prior to the institution of such suit, and if one portion of their complaint and/or claim is held at common law, by a court of original jurisdiction to be improper, invalid, unsubstantiated, insufficient, incomplete, and/or otherwise which adversely affects the original claim, they forfeited the amount deposited in the name of the arbitrator and the arbitration organization, to the arbitration organization to disperse as they deem fit. 7. In Section D, 2, only a party to the arbitration proceeding would file a motion to vacate under Section 23A1, or 2. However, the term person is used in Section 14E because a third party, that is, a person who is not party to the arbitration agreement or the arbitration proceeding, might bring an action against an arbitrator, for which they have no standing to do so. For instance, in multiple arbitration proceedings with subcontractors filing separate arbitration claims against General Contractor X, Arbitrator A may make an award in a case between General Contractor X and Subcontractor Y. In a later arbitration proceeding between General Contractor X and Subcontractor Z before Arbitrator B, Z may attempt to subpoena testimony or records from Arbitrator A in the prior proceeding, for which they have no standing as the arbitration proceedings does not concern them nor their interests as they are not a party to the arbitration and/or the arbitration award. Another possible scenario occurs when Arbitrator A issues a subpoena to T, a third party, and T decides to bring an action against Arbitrator A. In this instance, the subpoena being issued to Party T, Party T has the right to refuse the subpoena, and does not have to testify. In these instances, Arbitrator A has full immunity and the right to recover costs and attorney's fees under Section E against Z or T who would be persons but not necessarily parties to the arbitration proceeding between X and Y. 8. This does grant arbitrators or arbitration organizations immunity from criminal liability arising from their conduct in their arbitral or administrative roles. This comports with the sparse common law addressing arbitral immunity from criminal liability. See, for example, Ken v. ILGWU, 311 F2D 113, 114-15 3D Sayer, 1962. Babylon Milk and Cream Company v. Horowitz, 151 NYS 2D 221 NY Sup, Connecticut, 1956. These laws would not apply with reference to common law arbitration, and the fact that the arbitration organization is by law required to follow the law. So long as the arbitrator and the arbitration organization rely upon common law and decisions rendered by the Supreme Court of the United States of America in their original jurisdiction capacity, they cannot be held liable criminally or otherwise as a matter of law. The provision also draws no distinction between neutral arbitrators and advocate arbitrators. Both types of arbitrators are covered by this provision. Please note that the use of case law within this site, and/or the agreement, is in no way any submission and/or subjection to any other jurisdiction, other than the jurisdiction indicated herein, that is common law arbitration. There is no consent, and/or intent, and/or attempt to surrender any rights and/or waive any rights, and nothing at present, in the past, or in the future shall be construed so as to be deemed to the contrary of that which is stated herein. 26801. Ian and/or the Ian Foundation unregistered trademark respects the intellectual property of others. Copyright disclaimer under Section 107 of the Copyright Act 1976, allowance is made for fair use for purposes such as criticism, comment, news reporting, teaching, scholarship, and research. Arbitration Agreement WSEFH 7-3YEN1-5SD5FSDLHGSAU EGTF 1-6EEON Copyright by accessing, utilizing, and/or taking advantage of any information contained on this site, and/or services under any circumstance shall constitute your agreeing to the terms and conditions associated with the IAN and/or the IAN Foundation, Organization S, and/or its affiliates. You also agree that knowledge and/or information cannot be patented and/or copywritten, as knowledge cannot be the possession of any one person. Fair use is a use permitted by copyright statute that might otherwise be infringing, for no one person is the inventor of knowledge, as there is nothing new under the sun. Non-profit, educational or personal use tips the balance in favor of fair use. No copyright infringement intended. All rights belong to their respective owners. We take matters of intellectual property very seriously, and we are committed to meeting the needs of content owners while helping them manage publication of our content online. We are a non-profit education and information service provider, here to educate the public, and all of our work is in full compliance with the Fair Use Act. If you believe that your copyrighted work has been copied in a way that constitutes copyright infringement and is accessible on this site, you may notify our copyright agent, as set forth in the Digital Millennium Copyright Act of 1998 DMCA, ATTN, IAN and/or the IAN Foundation, 304 South Jones Boulevard, Unit IAN-1967, Las Vegas, Nevada, 89107. You must follow this address format precisely. No bulk, special, restricted, or otherwise mail will be accepted. We opt out and disaffirm an attempt to recontract and/or alter the terms of this agreement, and you forever agree and waive any and all rights to send bulk and/or parcel and/or legal and/or contractual communications to this address at any time, as such is strictly prohibited, and this disclaimer shall constitute an estoppel for the next 85 years continuously from day of issue or incident. We caution you that under federal law, if you knowingly misrepresent that online material is infringing, you may be subject to heavy civil penalties. These include monetary damages, court costs, and attorney's fees incurred by us, by any copyright owner, or by any copyright owner's licensee that is injured as a result of our relying upon your misrepresentation. You may also be subject to criminal prosecution for perjury. This information should not be construed as legal advice. For further details on the information required for valid DMCA notifications, see 17 U.S.C. 512C, 3, III, KV at 1010.10501. 3.1 Please understand that while EEON and/or the IAN Foundation the undersigned wishes and desires to resolve all disputed matters as promptly as possible, EEON and/or the IAN Foundation the undersigned can only do so upon Respondent's official response to this conditional acceptance for value and counteroffer claim for proof of claim by Respondent S, providing the undersigned with the requested and necessary proof of claims raised herein above. 1010.10502. 3.2 Therefore, as the undersigned is not a signatory, or a party, to your OSHIL compact contract, nor noticed nor cognizant of any agreement contract between you and the undersigned, and specifically any obtained through full disclosure and containing any fair valuable consideration therein, which would operate to create and establish a relationship nexus and thereby and therein bind the undersigned to the specific course of authority for the creation and existence of the alleged statute S/law S, as contained and allegedly promulgated within the code known as the United States Code, which, with the privity of contract or contract itself, would thereby and therein create and establish legal force and/or effect of said statute S/law S over and upon the undersigned, and would also operate to subject the undersigned to the statutory jurisdiction of the United States, its laws, venue, jurisdiction, and the like of its commercial courts, administrative tribunals, units, and thereby and therein bind the undersigned to said courts, administrative tribunals, units, decisions, orders, judgments, and the like. And specifically as within the above referenced alleged instant matter criminal case civil cause action upon exercise of a right, and which would operate to establish and confer upon said court, administrative tribunal, unit the necessary requirement essential of object matter jurisdiction, without which it is powerless to move in any action other than to dismiss. The undersigned once more respectfully requests the Respondent S provide said necessary proof of claim so as to resolve the undersigned's confusion and concerns within these matter S. Otherwise, the undersigned must ask, how is the undersigned's remedy? 1010.10503. This body having already failed to recognize the violations and the breach of oath of office by the public officials, acting as if they were all-powerful, acting as if they are not bound by their very same laws, claiming that they somehow are immune, that their oath of office is meaningless, I present and never submit, that the oath of office is a contract, a binding agreement, and while in office, they are bound by that contract and can be held liable for damages while acting under that contract. In conjunction with the other aforementioned bodies have acted as the keepers of the gate, have gate kept, has committed the illegal act of gatekeeping and are liable to the presenter petitioner for the amounts claimed in the complaint of treble damages. 1010.10504, 3.3. To the following the parties agree in fact and in substance that, a. that the presenter is an adult and is not a minor, an infant, a delinquent, a juvenile, a deceased person, an incompetent person, an insane person, but is completely within their competent mental faculty, documenting their attaining the age of majority, and having the right to gain control over the securities held in their minor account. B. The trustees, public officials, fiduciaries over the estates of minors hereby and herein agree to the aforementioned and to the surrendering to the undersigned full and complete control over the securities held in their minor and master accounts, plus 30% interest per annum, plus 60% interest per denum for any delays beyond the 10th business day of receipt of this presentment. C. The parties agree that the right to the securities belong to the security interest holder, which is the former minor, the age attaining adult, which gives no other party the right to hold and or maintain said securities without the undersigned's direct, explicit consent, and this contract documents the disaffirmance and the withdrawal of any consent, as this self-executing binding irrevocable contractual agreement coupled with interest supersedes and shall remain superior to any and all related contracts and or agreements prior to this agreement, heretofore, henceforth, and at present. This agreement shall remain in force for the next 99 fiscal years and or the year 2221 AD, whichever occurs first. D. The parties agree as stated above that the United States government is bankrupt, however, that the estates held in trust are not bankrupt, and the parties agree that any amount that cannot be paid with value shall be delivered in twice the amount of land asset, with the undersigned having the choice of land locations, of which none are to be construed as desert land, hazardous land, uninhabitable land. 1010.10505, 3.4. The undersigned herein and hereby provides the respondent S. 1010 calendar days to commence the day after receipt of this conditional acceptance for value and counteroffer claim for proof of claim, in which to gather and provide the undersigned with the requested and necessary proof of claims raised herein above, with the instruction to transmit said proof of claims to the undersigned and the below named notary third party for the sole purpose of certifying response or want thereof from respondent S. Further, the undersigned herein and hereby extends to the respondent S. the offer for an additional 1010 calendar days in which to provide the requested and necessary proof of claims raised herein above. If respondent S. desires the additional 1010 calendar days, respondent must cause to be transmitted to the undersigned and the below named notary third party a signed written request. Upon receipt thereof, the extension is automatic. However, the undersigned strongly recommends the respondent S. make request for the additional 1010 calendar days well before the initial 1010 calendar days have elapsed to allow for mailing time. Notice, should respondent S. make request for the additional 1010 calendar days, said request will be deemed good faith on the part of respondent S. to perform to this offer and provide the requested and necessary proof of claims. Should respondent S. upon making request for the additional 1010 calendar days then fail or otherwise refuse to provide the requested and necessary proof of claims, said act S. on the part of respondent S. shall be deemed and evidenced as fraud, deception, bad faith, unclean hands and the like upon respondent S. part and further attempts to cause and inflict injury upon the undersigned. Further, the undersigned herein strongly recommends to respondent S. that any proof of claims and request for the additional 1010 calendar days be transmitted delivery confirmation mail, return receipt requested and the contents therein under proof of mailing for the good of all concerned. 1010.10506. 3.5 Should the respondent S. fail and or not respond directly to each proof of claim with specific specificity or otherwise refuse to provide the requested and necessary proof of claims raised herein above within the expressed period of time established and set herein above, respondent S. will have failed to state any claim upon which relief can be granted. Further, respondent S. will have agreed and consented through a cit acquiescence to ALL the facts in relation to the above referenced alleged instant matter criminal case civil cause action upon exercise of a right, as raised herein above as proof of claims herein. and all facts necessarily and of consequence arising therefrom, are true as they operate in favor of the undersigned, and that said facts shall stand as prima facie and ultimate unrefutable between the parties to this conditional acceptance for value and counteroffer claim for proof of claim. The corporate government juridical construct S, respondent S, represents, serves, and ALL officers, agents, employees, assigns, and the like in service to respondent S, as being undisputed. Further, failure and/or refusal by respondent S to provide the requested and necessary proof of claims raised herein above shall operate as ratification by respondent S that ALL facts as set, established, and agreed upon between the parties to this conditional acceptance for value and counteroffer claim for proof of claim are true, correct, complete, and not misleading. 3.5. Should the respondent S fail and/or not respond directly to each proof of claim with specific specificity or otherwise refuse to provide the requested and necessary proof of claims raised herein above within the expressed period of time established and set herein above, respondent S will have failed to state any claim upon which relief can be granted. Further, respondent S will have agreed and consented through a cit acquiescence to ALL the facts in relation to the above referenced and/or associated alleged criminal case cause, as raised herein above as proof of claims herein. And ALL facts necessarily and of consequence arising therefrom, are true as they operate in favor of the undersigned, and that said facts shall stand as prima facie and ultimate unrefutable between the parties to this conditional acceptance for value and counteroffer claim for proof of claim. The corporate government juridical construct S, respondent S, represents, serves, and ALL officers, agents, employees, assigns, and the like in service to respondent S, as being undisputed. Further, failure and/or refusal by respondent S to provide the requested and necessary proof of claims raised herein above shall operate as ratification by respondent S that ALL facts as set, established, and agreed upon between the parties to this conditional acceptance for value and counteroffer claim for proof of claim are true, correct, complete, and not misleading. IV. Arbitration and administrative remedy cognizable at common law 10,000. Additionally, it is exigent and of consequence for the undersigned to inform respondent S, in accordance with and pursuant to the principles and doctrines of lean hands and good faith, that by respondent S, failure and/or refusal to respond and provide the requested and necessary proof of claims raised herein above and thereby, and it shall be held and noted and agreed to by all parties, that a general response, a non-specific response, or a failure to respond with specificities and facts and conclusions of common law, and/or to provide the requested information and documentation that is necessary and in support of the agreement shall constitute a failure and a deliberate and intentional refusal to respond, and as a result thereby and/or therein, expressing the defaulting party's consent and agreement to said facts, and as a result of the self-executing agreement, the following is contingent upon their failure to respond in good faith, with specificity, with facts and conclusions of common law to each and every averment, condition, and/or claim raised. As they operate in favor of the undersigned, through a cit acquiescence, respondent S, not only expressly affirm the truth and validity of said facts set, established, and agreed upon between the parties to this conditional acceptance for value and counteroffer claim for proof of claim, but respondent S, having agreed and consented to respondent S, having a duty and obligation to provide the requested and necessary proof of claims raised herein above, will create and establish for respondent S, an estoppel in this matter S, and ALL matters relating hereto, and arising necessarily therefrom. And, 49,230. 1000A. The parties also agree that the arbitration rules of the Arbitration Association, otherwise known as EON and/or the EON Foundation, shall apply, and that no statute and/or statutory law shall supersede and/or override this agreement. That the arbitrator is strictly prohibited from acting outside the scope and bounds of this agreement when determining matters concerning this agreement between the parties, as this contract shall become binding upon the arbitrator when rendering a decision concerning and/or involving and/or related directly and/or indirectly to this instant matter. And, 49,231. The parties further agree that this contract shall supersede and take precedent over any and all other agreements made or entered into prior and/or after the fact, and that any portion of this contract deemed or held to be invalid shall not invalidate any other portion of this contract. That this contract is to be perceived and/or conceived and/or construed contextually and not otherwise under any circumstances. that in petitioning a court for a motion to confirm arbitration award, the court may only address the issue directly associated with confirming the arbitration award as specified in the Federal Arbitration Act and no other, unless it can definitively prove what facts and conclusions of law that the arbitrator acted outside the scope of the arbitrator's authority as specified within this agreement. The court shall have no jurisdiction and/or consent to do anything other than confirm the award and/or enforce the agreement. The court shall be a court having the power of original jurisdiction, may only sit in equity, and must render an order confirming the award as requested and/or vacating the award documenting facts and conclusions of constitutional and the common law, and not statutory law, codes, ordinance, procedures, rules, regulations, as these operate contrary to the wishes of the parties and the contractual agreement that is binding upon all parties, and by its inclusion and/or interference and/or its involvement the court accepts these terms, and agrees to be bound by them, thus waiving any and all rights to any declared sovereignty and/or immunity for the next 180 calendar years. 49,232, 10,001. In accordance with and pursuant to this agreement. A contractually consensual binding agreement between the parties to this conditional acceptance for value and counteroffer claim for proof of claim to include the corporate government agency Department Construct S, whom Respondent S represents serves, as well as ALL officers, agents, employees, assigns, and the like in service to Respondent S, will not argue, controvert, oppose, or otherwise protest any of the facts already agreed upon by the parties set and established herein, and necessarily and of consequence arising therefrom, in any future remedial proceeding S/action S, including binding arbitration and confirmation of the award in the Court of the United States of America at any competent court under original jurisdiction, in accordance with the general principles of non-statutory arbitration, wherein this conditional acceptance for the value agreement contract no. WSEFH 7-3YEN1-5SD5FSDLHGSAE WEGTF 1-6EEON copyright constitutes an agreement of all interested parties in the event of a default and acceptance through silence failure to respond when a request for summary disposition of any claims or particular issue may be requested and decided by the arbitrator, whereas a designated arbitrator shall be chosen at random, who is duly authorized, and in the event of any physical or mental incapacity to act as arbitrator, the undersigned shall retain the authority to select any neutral S/arbitrator S that qualify pursuant to the common law right to arbitration, as the arbitration process is a private remedy decided upon between the parties, and with respect to this agreement, the defaulting party waives any and all rights, services, notices, and consents to the undersigned and/or the undersigned's representative selection of the arbitrator, thereby constituting agreement, and any controversy or claim arising out of or relating in any way to this agreement or with regard to its formation, interpretation or breach, and any issues of substantive or procedural arbitrability shall be settled by arbitration, and the arbitrator may hear and decide the controversy upon evidence produced although a party who was duly notified of the arbitration proceeding did not appear. That the undersigned deems necessary to enforce the good faith of ALL parties hereto within without respect to venue, jurisdiction, law, and form the undersigned deems appropriate. 49,233. As by law, when a contract has an arbitration clause that requires the arbitrator determine the validity of the contract, and the arbitration clause, the courts have no business in the matter. Henry Schein, Incorporated v. Archer and White Sales, Incorporated, number 17-1272 U.S. Sup. CT January 8, 2019, ND. That courts must respect the parties' decision in their contracts to delegate the arbitrability question to the arbitration panel. 49,234. F. The arbitration clause clearly and unmistakably delegates questions of arbitrability to the arbitration panel, then these issues will be decided by the arbitrators and not the courts. If the AA allows parties to agree by contract that an arbitrator, rather than a court, will resolve threshold arbitrability questions as well as the underlying merits disputes, the courts are not at liberty to rewrite the statute passed by Congress and signed by the President. This quote may become more relevant if manifest disregard continues to rear its head. E must interpret the FAA as written, and the FAA in turn requires that we interpret the contract as written. And the party's contract delegates the arbitrability question to an arbitrator. A court may not override the contract. That is true even if the court thinks, that is to say, it matters not what the court thinks. What matters is the Federal Arbitration Act and the intentions of Congress. The alleged exception gave a party resisting arbitration an out if it could convince a court that the issue in dispute clearly did not come within the arbitration clause. That out is now gone, or as Justice Kavanaugh said in the opinion, that ship has sailed. that the argument that the arbitration agreement applies to a particular dispute is wholly groundless. We may not engraft our own exceptions onto the statutory text. And finally, T is not our proper role to redesign the statute. 49,235. We bring to everyone's attention that the Supreme Court has made it clear that there is no judicial discretion when it comes to arbitration where the arbitrator and/or questions regarding arbitration are a part of a contract, whereby the parties having agreed. In this instance, the parties have agreed to have any and all questions, disputes associated with the agreement settled and determined by an arbitrator as specified within the terms of the agreement. 49,236. In this matter, contract number 6SAA 6267-3570N1QWS 49LHGSAEK2KF1-6EEO and Copyright and Associated Private Secret Express Trust Agreement 1,765,438,794 3PMGXY18741EEO and Copyright, it having been agreed by the parties, that this contractual agreement accompanied by an arbitration clause is binding, irrevocable, self-executing, and coupled with interests, and as noted above, the contract specifically addressed the issue as to questions dealing with the validity of the contract, that such was only to be determined by the arbitrator and not the court. 49,237. The arbitrator in issuing the award is to be perceived by such actions as providing evidence that the contract is valid, and that the contract is valid, and that means that its terms, conditions, clauses are valid as well. We as a party possess the right to petitions for the enforcement of the contract and not just the confirmation of the award, which is our intent in and through this instance. 49,238. The opposing party, no matter who they may be, waives all rights, defenses, and/or objections and agrees to being estopped bringing forth any complaint and/or dispute, and that if such was brought it would be through arbitration, as arbitration shall be the sole and exclusive remedy for resolving any and all issues concerning the parties, the related matters, and/or any relationship conflicts and/or controversies. This is a matter of and involving equity, as equity must render equity. 49,239. The contract itself stands as an express trust agreement, whereby this petitioner's estate is the grantor-truster and the opposing party grantee. The petitioner in their natural capacity is the beneficiary of the trust, the government agency special relationship trustee. The value includes the contract trust agreement, which is property as defined by the Fifth Amendment of the United States Constitution. The contract trust agreement has an end date, is workable, thus satisfying all of the prerequisites for expressing and/or declaring the trust. 49,240. The matter involved commerce, so we invoke the Federal Arbitration Act, otherwise known as the United States Arbitration Law. Court has no business weighing the merits of the grievance because the agreement is to submit all grievances to arbitration, not merely those which the court will deem meritorious. Id. At 650 quoting Steelworkers v. American MFG. Co. 363 U.S. 564, 568 1960. 49,241. We further bring to your attention that the courts cannot act outside the scope of the intentions of Congress. Here is the intentions of Congress and what they had to say with regards to legislative intentions respecting the United States Arbitration Act, otherwise known as the Federal Arbitration Act. 49,242. By enacting Section 2, Congress sought generally to promote the enforcement of arbitration agreements. Historically, American courts viewed arbitration with judicial hostility. It is believed that this hostility flowed from a similar enmity displayed by English courts. Arbitration infringed on the livelihood of English judges who were paid fees based on the number of cases they decided. English courts were also generally unwilling to surrender their jurisdiction over various disputes. The hostility toward arbitration subsided as industrialization led to an increased number of business disputes. In 1924, the court upheld a New York law that compelled arbitration in a dispute involving a maritime contract. The court's decision in Red Cross Line v. Atlantic Fruit Company is believed to have opened the door for federal legislation that recognized the validity of arbitration agreements. President Calvin Coolidge signed the United States Arbitration Act, commonly referred to as the Federal Arbitration Act, on February 12, 1925. The enactment of the new law declared a national policy favoring arbitration and withdrew the power of the states to require a judicial forum for the resolution of claims which the contracting parties agreed to resolve by arbitration. While Congress's primary motivation for drafting the FAA reflected its interest in protecting the enforcement of arbitration agreements as agreed to by the contracting parties, it also understood the potential benefits that would be provided by the law's enactment. It is practically appropriate that the action should be taken at this time when there is so much agitation against the costliness and delays of litigation. 49,243. These matters can be largely eliminated by agreements for arbitration, if arbitration agreements are made valid and enforceable. Although Section 2 of the FAA requires the enforcement of arbitration agreements in maritime transactions and contracts evidencing a transaction involving commerce, the precise scope of this latter group of contracts has not always been certain. Congress provided a definition for the term commerce in Section 1 of the FAA, but it did not identify the extent to which a contract must evidence a transaction involving commerce before the FAA would apply. The courts held that the Section 2 phrase involving commerce reached to the limits of Congress's power under the Commerce Clause. In Snyder v. Smith, for example, the U.S. Court of Appeals for the Seventh Circuit maintained that the courts should take into account Congress's broad power to regulate under the Commerce Clause when deciding which contracts involve commerce. Because Congress may reach activities affecting interstate commerce under its Commerce Clause authority, the Seventh Circuit reasoned that it was logical to conclude that any contract affecting interstate commerce falls under Section 2 of the FAA. In 1995, the Supreme Court determined that a broad interpretation of involving commerce is appropriate. In Allied Bruce Term Index Companies, Incorporated v. Dobson, the court held in a 7-2 opinion authored by Justice Breyer that the phrase involving commerce signaled the full exercise of Congress's power under the Commerce Clause. The court concluded that the FAA's legislative history indicates an expansive congressional intent. For example, the House report that accompanied the FAA stated that the Act's control over interstate commerce reaches not only the actual physical interstate shipment of goods but also contracts relating to interstate commerce. In addition, remarks in the congressional record indicated that the FAA affects contracts relating to interstate subjects and contracts in admiralty. The court maintained that 20 H.R. RAP. Number 96, Supra Note 10 at 2. 21 C9 U.S.C. Section 1. The word NVOLVE should be read as the functional equivalent of the word FECT. Because the phrase affecting commerce normally signals Congress's intent to exercise its Commerce Clause powers to the fullest extent, the court reasoned that the use of the phrase involving commerce should be given a similar reading. After concluding that the phrase involving commerce should be interpreted broadly, the Dobson Court further determined that the FAA applies to all contracts that involve commerce and does not require the contemplation of an interstate commerce connection by the parties. The court found that a contemplation of the parties' requirement was inconsistent with the FAA's basic purpose of helping parties avoid litigation. Such a requirement invited litigation about what was or was not contemplated by the parties. Any congressional recognition of an expedited dispute resolution system at the time the FAA was drafted would be undermined by this additional litigation. Commerce means commerce among the several states or with foreign nations, or in any territory of the United States or in the District of Columbia, or between any such territory and another, or between any such territory and any state or foreign nation, or between the District of Columbia and any state or territory or foreign nation. 49,244. We include this information as a basis for the preponderance of evidence to the contrary of any claim that the matter does not involve commerce, that the contract between the parties that involve commerce does not invoke the Federal Arbitration Act, and that the arbitration agreement does not incorporate such issues, including the intentions of Congress when enacting such an act. 49,245. This is a matter of equity, dealing with a contractual trust relationship, and is subject to the rules, principles, and standards of equity. The Federal Arbitration Act is an equitable statute, in that it requires an agreement of all parties. The contract with an arbitration clause is documentation of agreement of all parties. The Supreme Court decision in Henry Schein, Incorporated v. Archer and White Sales, Incorporated, number 17-1272 U.S. Sup. CT January 8, 2019, the court held that such contracts to include issues of viability, validity, disputes, controversies, and/or issues are to be resolved before an arbitrator when the contract and arbitration agreement so dictate. In this very instance the contract makes such dictation. 49,246, 10,002. Further, Respondent S. agrees the undersigned can secure damages via financial lien on assets, properties held by them or on their behalf or ALL injuries sustained and inflicted upon the undersigned for the moral wrongs committed against the undersigned as set, established, agreed and consented to herein by the parties hereto, to include but not limited to, constitutional impermissible misapplication of statute S/law S, in the above referenced alleged commercial civil cause. Fraud, conspiracy to or more involved. Trespass of title, property, and the like. And, ALL other known and unknown trespasses and moral wrongs committed through ultra vires act S, of ALL involved herein. whether by commission or omission. Final amount of damages to be calculated prior to submission of tort claim and or the filing of lien and the perfection of a security interest via a uniform commercial code financing one statement. Estimated in excess of $1 million USD or other lawful money or currency generally accepted with or by the financial markets in America, as the value of this claim established at $25,000 per 2323 minutes, $1,600,000 million per day. And punitive damages within the above referenced alleged criminal case cause. C. Trezaven v. City of Tampa, 741 F2D 336 1984, wherein damages were set as $25,000 per 2323 minutes in a false imprisonment case. And notice to Respondent S, by invoice. Per Respondent S, failure and or refusal to provide the requested and necessary proof of claims and thereby and therein consenting and agreeing to ALL the facts set, established, and agreed upon between the parties hereto, shall constitute a self-executing binding irrevocable durable general power of attorney coupled with interests. This conditional acceptance for value and counteroffer claim for proof of claim becomes the security agreement under commercial law whereby only the non-defaulting party becomes the secured party, the holder in due course, the creditor in and at commerce. It is deemed and shall always and forever be held that the undersigned and any and all property, interest, assets, estates, trusts commercial or otherwise shall be deemed consumer and household goods not for profit and or gain, private property, and exempt, not for commercial use, non-taxable as defined by the Uniform Commercial Code Article 9 Section 102 and Article 9 Section 109 and shall not in any point and or manner, past, present and or future be construed otherwise see the Uniform Commercial Code Article 3, 8, and 9. 10,003. Should Respondent S allow the 1010 calendar days or 2020 calendar days total if request was made by signed written application for the additional 1010 calendar days to elapse without providing the requested and necessary proof of claims, Respondent S will go into fault and the undersigned will cause to be transmitted a notice of fault and opportunity to cure and contest acceptance to the Respondent S, wherein Respondent S will be given an additional 3 days 72 hours to cure Respondent's S fault. Should Respondent S fail or otherwise refuse to cure Respondent's S fault, Respondent will be found in default and thereby and therein, Respondent will have established Respondent's S consent and agreement to the facts contained within this conditional acceptance for value and counteroffer claim for proof of claim as said facts operate in favor of the undersigned. For example, that the judgment of alleged of record within the above referenced alleged commercial civil cause is void ab initio for want of subject matter jurisdiction of said venue. Insufficient document information and affidavits in support thereof for want of establishing a claim of debt. Want of relationship with the heirs of authority for said statute S/law S, for want of privity of contract, or contract itself. Improperly identified parties to said judgment, as well as said dispute matter. And, Respondent S, agrees and consents that Respondent S, does have a duty and obligation to undersigned, as well as the corporate government department agency Construct S, Respondent S, represent serves, to correct the record in the above referenced alleged commercial civil cause and thereby and therein, release the indenture however term styled upon the undersigned and cause the undersigned to be restored to liberty, and releasing the undersigned's property rights, as well as ALL property held under a storage contract in the aim of the all capital letter aim defendant within the above referenced alleged commercial civil cause within the alleged commercially owned warehousing agency DBA, for the commercial corporate government construct DBA. The United States. That this presentment is to be construed contextually and not otherwise, and that if any portion and or provision contained within this presentment, this self-executing binding irrevocable contractual agreement coupled with interests, is deemed or held as inapplicable and or invalid, it shall in no way affect any other portion of this presentment. That the arbitrator is permitted and allowed to adjust the arbitration award to no less than 2 times the original value of the properties associated with this agreement, plus the addition of fines, penalties, and other assessments that are deemed reasonable to the arbitrator upon presentment of such claim, supported by prima facie evidence of the claim. 10,004. The defaulting party will be stopped from maintaining or enforcing the original offer presentment. That is, the above referenced alleged commercial civil cause as well as ALL commercial paper negotiable instruments therein, within any court or administrative tribunal unit within any venue, jurisdiction, and forum the undersigned may deem appropriate to proceed within in the event of any and ALL breach S, of this agreement by Respondent S, to compel specific performance and or damages arising from injuries therefrom. the defaulting party will be foreclosed by laches and/or estoppel from maintaining or enforcing the original offer presentment in any mode or manner whatsoever, at any time, within any preceding action. Furthermore, the respondents are foreclosed against the enforcement, retaliation, assault, infringement, imprisonment, trespass upon the rights, properties, estate, person whether legal, natural or otherwise of the presenter petitioner and/or his interest and/or his estate retroactively, at present, post-actively, forever under any circumstances, guise, and/or presumption. I. Notice of Common LAW Arbitration, 10,005. Please be advised that inasmuch as the undersigned has accrued the interest in the aim of the all-capital letter aim defendant has employed used upon the face and within ALL documents instruments records within the above referenced alleged commercial civil cause, to include any and all derivatives and variations in the spelling of said aim except the rue name of the undersigned as appearing within the undersigned signature block herein below, through a common law copyright, filed for record within the Office of the Secretary of State, Las Vegas, State of Nevada, and, having affected said interest in same through incorporation within a financing and all amendments and transcending filings thereto, by reference therein, the undersigned hereby and herein waives the undersigned's rights as set, established, and the like therein, and as are affected within said financing statement acting operating to register said copyright, to allow for the respondent S. to enter the record of the alleged art of record within the above referenced alleged commercial civil cause for the SOLE purpose to correct said record and comply with respondent's S. agreed upon duty obligation to write the RDER and cause same to be transmitted to restore and release the undersigned S. corpus, and ALL property currently under a torage contract under the undersigned's common law copyrighted trade name. That is, the all-capital letter aim defendant within the above referenced alleged commercial civil cause, within the alleged commercially owned warehousing agency DBA. The commercial corporate government juridical construct DBA. The United States. Please take special note that the copyright is with reference to the name and its direct association and/or correlation to the presenter. 49,247. As has been the case, contracts are property. Please note that any use of any statutory term and/or statutory law does in no way invalidate the provisions of this agreement and/or do prohibitions of any party from utilizing statute in the enforcement and/or consideration for the validity of any point and/or issue associated with this agreement, as the use of statutory terms and/or codes and/or regulations and/or laws is for reference purposes only and shall not affect the strength, validity, and/or effectiveness of the agreement under any circumstances. As was held by the Supreme Court of the United States in Lynch v. United States, 292 U.S. 571, 579 1934, A. The Fifth Amendment commands that property be not taken without making just compensation. Valid contracts are property, whether the obligor be a private individual, a municipality, a state or the United States. Rights against the United States arising out of a contract with it are protected by the Fifth Amendment. United States v. Central PR Company, 118 U.S. 235, 238. United States v. Northern PR Company, 256 U.S. 51, 64. When the United States enters into contract relations, its rights and duties therein are governed generally by the law applicable to contracts between private individuals. That the contracts of war risk insurance were valid when made is not questioned. As Congress had the power to authorize the Bureau of War Risk Insurance to issue them, the Due Process Clause prohibits the United States from annulling them, unless, indeed, the action taken falls within the federal police power or some other paramount power. 49,248. Perry v. United States, 294 U.S. 330, 352-353 1935. When the United States, with constitutional authority, makes contracts, it has rights and incurs responsibilities similar to those of individuals who are parties to such instruments. There is no difference, said the court in United States v. Bank of Metropolis, 15 Pet. 977, 392, except that the United States cannot be sued without its consent. See, also, the Floyd Acceptances Pierce v. United States 7 Wall, 666, 675. Cook v. United States, 91 U.S. 389, 396. In Lynch v. United States, 292 U.S. 571, 580, with respect to an attempted abrogation by the Act of March 20, 1933 48 Stat. At L8, 11, Chap. 3. U.S.C. Title 38, Section 701, of certain outstanding war risk insurance policies, which are contracts of the United States. The court quoted with approval the statement in the sinking fund cases, 99 U.S. 70, supra, and said, punctilious fulfillment of contractual obligations is essential to the maintenance of the credit of public as well as private debtors. No doubt there was in March, 1933, great need of economy. In the administration of all government, business economy had become urgent because of lessened revenues and the heavy obligations to be issued in the hope of relieving widespread distress. Congress was without power to reduce expenditures by abrogating contractual obligations of the United States. To abrogate contracts, in the attempt to lessen government expenditure, would be not the practice of economy, but an act of repudiation. 49,249. 10,006a. The introduction of the aforementioned information is to document the fact that this contract is property. EEON and/or the EIN Foundation are the sole owner of this agreement as grantor. Any respondent and/or associated party and/or third party shall be reduced to a special relationship trustee position. The beneficiaries of this agreement shall be the partners of the EEON and/or the EIN Foundation and Association Organization S, who are identified as members of the Commission, and those they identify through the SAPIC and Defrauded Homeowners of America program. S, and any other party they may so designate, which they may remove such a party according to their policies and procedures at their discretion in line with such policies and procedures in place at the time of such removal. This agreement shall constitute a pure trust express trust agreement, and the trustee in addition to the special relationship trustee noted above shall be in addition the provincial government known as the United States, its agencies, organizations, departments, groups, associations, assigns, successors, heirs, future delegatory organizations and/or agencies, United States Department of Defense, the United States Military, the Administrative Office of the United States Courts, the United States Supreme Court, the United States Congress and General Assembly, United States Federal Court System to include its judges, officers, agents, etc. al. the EDI. Gen. its assigns, successors. Each individual state of the United States and/or instrumentality of the United States that is not a natural man and/or woman and/or natural offspring of a man and/or woman. 49,250. 10,006b. The aforementioned additional special relationship trustee shall relinquish control and/or possession of any and all assets, properties, monies, records, files, persons legal or otherwise, surveillance, custody, detention, subjections, servitudes, contracts, agreements, trust, estates, securities, and the like to the care of the beneficiary, otherwise known as the Threat Outbreak Preparedness Program or TTOPP. A non-profit organization who shall then distribute to the proper owner, age of majority attaining man or woman associated with the aforementioned securities and/or assets etc. al. who are a party to this agreement, directly and/or indirectly related. TTOPP shall permit the trustee to withhold 25% of the value of each estate as a loan to the United States to be paid back over the course of 30 years, at a percentage rate of 10% of the value and no greater than 17% of the value, which shall be at the sole discretion of the account holder identified by TTOPP. For the maintenance and operation of government, with the exception that none of the 25% is to be utilized for military purposes under any circumstances, as TTOPP. And the beneficiaries are peaceful parties, and does not advocate and/or support violence of any kind, and it would be a violation of their right to practice religion to misconstrue the aforementioned as not their right of intent. 49,251. 10,006c. This contract shall be irrevocable, it cannot be invalidated, superseded, revoked, ignored, outdated, subjugated, removed, displaced, replaced, obstructed, supplanted, placed in jeopardy, and servitude, disregarded, construed other than contextually, recontracted, rewritten, as he grantor's intentions is law of the trust and the grantor's intentions are clearly expressed throughout and shall never be deemed and/or held and/or viewed as ambiguous with reference thereto. 49,252. 10,006. Notice that the arbitrators must not necessarily judge according to the strict law, but as a general rule ought chiefly to consider the principles of practical business. Norski Atlas Insurance Company v. London General Insurance Company 1927, 28 Lloyd's List Rep 104. Internationally accepted principles of law governing contractual relations. Deutsche Schachtbau v. RAS Alkema National Oil Company 1990, 1 AC 295. If the contract valid or otherwise contains an arbitration clause, then the proper forum to determine whether the contract is void or not is the arbitration tribunal. For example, see Heyman v. Darwin's Limited 1942, AC 356, that any determination by the arbitrator is binding upon all parties, and that all parties agree to abide by the decision of the arbitrator, that the arbitrator is to render a decision based upon the facts and conclusions as presented within the terms and conditions of the contract. Any default by any party must be supported by proof and evidence of said default. That default shall serve as tacit acquiescence on behalf of the party who defaulted as having agreed to the terms and conditions associated with the self-executing binding irrevocable contract coupled with interests. That the arbitrator is prohibited from considering and/or relying on statutory law, as it has been held that any time any party relies on or enforces a statute, they possess no judicial power. Judge ceases to sit as a judicial officer because the governing principles of administrative law provides that courts are prohibited from substituting their evidence, testimony, record, arguments and rationale for that of the agency. Additionally, courts are prohibited from substituting their judgments for that of the agency. AISIVUS 568 F2D 284. Judges who become involved in enforcement of mere statutes, civil or criminal in nature and otherwise, act as mere clerks of the involved agency. K.C. Davis, Admin. LAW, CH1 CTP. West's 1965 ed. Their supposed court becoming thus a court of limited jurisdiction as a mere extension of the involved agency for mere superior reviewing purposes. K.C. Davis, Admin. LAW, pages 95, CTP, 6 ed. West's 1977, FRCVGE. 28 IUS 464. Keller VPE, 261 US 428. When acting to enforce a statute, the judge of the municipal court is acting an administrative officer and not as a judicial capacity. Courts in administrating or enforcing statutes do not act judicially, but merely administerially. Thompson v. Smith, 155 A, 376, L54 SE 583, 7 LALR 604. It is basic in our law that an administrative agency may act only within the area of jurisdiction marked out for it by law. If an individual does not come within the coverage of the particular agency's enabling legislation, the agency is without power to take any action which affects him. Endicott v. Perkins, 317 U.S. 501. It is not every act, legislative in form, that is law. Law is something more than mere will exerted as an act of power. Arbitrary power, enforcing its edicts to the injury of the person and property of its subjects, is not law. Hurtado v. California 1884, 110 U.S. 515 1984. Some of the aforementioned cases are not published, however, these are still fundamental principles of law, and one of the fundamental principles of arbitration is that the arbitrator sits as judge over the facts, and as such, to preserve the sanctity of the process, an arbitrator receives the same immunity as a judge and is exempt from prosecution and/or review, unless it can be proved that the arbitrator intentionally ignored the evidence and acted in conspiracy to defraud the parties. As indicated by this agreement, all parties associated hereto directly and/or indirectly agree under penalty of imprisonment for no less than 5 years to hold the arbitrator and the arbitration association associated with this matter totally and completely immune from all consequences resulting from his or her carrying out their duties associated with this instant matter. That to protect the sanctity and the honor of the arbitration system, the parties agree that the arbitrator's decision shall be final and binding upon all parties, and that no party shall attempt to retaliate, challenge, appeal, dispute, charge, allege, complain, and/or otherwise cause harm, stress, burden, conflict to the arbitrator and/or the arbitration association with any matter associated hereto, directly or indirectly heretofore, henceforth, and any such attempt shall be held null and void. That arbitration is the exclusive remedy for the parties, and that only the original arbitrator and/or that person's designee shall have the right to reconsider and/or amend the arbitration award, but only under the terms as specified within this agreement, and not otherwise. No other party except the arbitrator shall have the right of determining the validity of this contract, as the parties agree that this contract is a sufficient agreement documenting and detailing the consensus and understanding of the parties as of the institution of this agreement, which shall take full effect 10 calendar days after receipt and/or upon default. 10,007. As the undersigned has no desire and/or wish to tie the hands of Respondent S. in performing Respondent's S. agreed upon duty obligation as set, established, and agreed upon within this conditional acceptance for value and counteroffer claim for proof of claim and thereby create cause or reach of said contractually binding agreement on the part of the Respondent S. Respondent S. is hereby and herein noticed that if this waiver of said copyright is not liberal nor extensive enough to allow for the respondent S to specifically perform all duties obligations as set, established, and agreed upon within the conditional acceptance for value and counteroffer claim for proof of claim, respondent S may, in good faith and not in fraud of the undersigned, take all needed and required liberties with said copyright and this waiver in order to fulfill and accomplish respondent's S duties obligations set, established, and agreed upon between the parties to this agreement. It shall be noted that no typo, misspelled word, and/or grammatical defect and/or error shall have any effect on the overall context of this contract and/or its validity. That as stated, this instrument shall be and forever shall remain contextually construed and never otherwise, and all parties agree hereinto on to the same. 10,008. If Respondent S has any questions and/or concerns regarding said copyright and/or the waiver, Respondent S is invited to address such questions and/or concerns to the undersigned in writing, and causing said communiques to be transmitted to the undersigned and below named notary third party. The respondents have acted as if the contract quasi or otherwise does not place a binding obligation upon their persons, upon their organizations, upon their institutions, upon their job qualifications, and breaching that obligation breaches the contract, for which they cannot address due to the direct conflict of interest. It is as a result of that conflict of interest that binding arbitration shall be instituted. 10,009. Your failure to respond, and this would include each of the respondents by their representative, and if represented by the Gen, such representation must be responsive for each state and/or state organization, department, agency, separately and severally to each of the points of averment. Failure to respond to a single point of averment will constitute acquiescence, forfeiture, and a waiver of all rights with respects all of the points raised in this presentment. II. Notice to agent is notice to principal and vice versa. 10,010. Notice, in this conditional acceptance for value and counteroffer claim for proof of claim A, the words NCLUDE, includes, and including, are not limiting. B. The word LL includes NI and the word NI includes LLC. The word R is not exclusive except when used in conjunction with the word ND as in, ND or AND. Words and terms I in the singular number include the plural, and in the plural, the singular. E in the masculine gender include both feminine and neuter. That due to the fact that this presentment document contract can only be construed contextually and not otherwise, it is not necessary for a question to contain A, and whether or not A is followed by a specific question, such instances does not excuse a party from having an obligation of responding with specificity and facts and conclusions of common law. 10,011. This presentment shall constitute a claim against the assets of you and/or your institution and is valid upon your and/or your institution's and/or your agency and/or your organization's failure to comply with the requirement of this agreement and to validate not verify the comprehensive accounting in every aspect. This presentment shall constitute a claim against the assets of your institution and is valid upon your failure to comply with the requirement of this agreement and to validate not verify the comprehensive accounting. Most people do not understand the concept of validation of debt. The federal codified statute to companies for validation. Let's note the definitions. Validation, recognition or affirmation that a person or their feelings or opinions are valid or worthwhile. Verification, N. The declaration under oath or upon penalty of perjury that a statement or pleading is true, located at the end of a document. A typical verification reads, I declare under penalty of perjury under the laws of the state of California, that I have read the above complaint and I know it is true of my own knowledge, except as to those things stated upon information and belief, and as to those I believe it to be true. Executed January 3, 1995, at Monrovia, California. Signed Georgia Garner, declarant. If a complaint is verified, then the answer to the complaint must be verified. C. Complaint, answer, oath. Under the FDCPA both validation and verification go as a couple's liability with respects communal property. Note, Sect. 1692 G83, a statement that unless the consumer, within 30 days after receipt of the notice, disputes the validity of the debt, or any portion thereof, the debt will be assumed to be valid by the debt collector. 4. A statement that if the consumer notifies the debt collector in writing within the 30-day period that the debt, or any portion thereof, is disputed, the debt collector will obtain verification of the debt or a copy of a judgment against the consumer and a copy of such verification notice, all titles, names, appellations of corporate government juridical constructs, and branches, departments, agencies, bureaus, offices, sub-whatevers, and the like thereof, include any and all derivatives and variations in the spelling of said titles. /names appellations. That boards contained within this agreement shall have their natural meaning and rendition unless otherwise indicated. that the reliance on Private Law 114-31 and the findings of the United States Congress that contracts similar to this are deemed valid, binding, enforceable, and irrevocable, as notification is provided so that no one may bring forth a claim of fraud, which requires all elements to be proved on the record, to prove a conspiracy under 18 U.S.C. Section 371, party bringing such a claim must establish 1. An agreement to engage in criminal activity, 2. One or more overt acts taken to implement the agreement, and 3. The requisite intent to commit the substantive crime. United States v. Kaplan, 836 F3D 1199, 1212 9th Circle, 2016, citation and internal quotation marks omitted. The agreement need not be explicit. It is sufficient if the conspirators knew or had reason to know of the scope of the conspiracy and that their own benefits depended on the success of the venture. United States v. Montgomery, 384 F3D 1050, 1062 9th Circle, 2004, citing United States v. Romero, 282 F3D 683, 687 9th Circle, 2002. A conspiracy may exist even if some members of the conspiracy cannot complete the offense, so long as the object of the conspiracy is that at least one conspirator complete the offense. Ocasio v. United States, 136 SCT, 1423, 1429-32 2016. The elements of fraud are similar to those of conspiracy. Note the following and what must be done. From securities purchases to real estate and commercial acquisitions, common law fraud can impact nearly any transaction. See Maturo v. Gerard, 196 Con. 584, 587, 494 A2D 1199, 1201 1985, Rod. Cannot be easily defined because it can be accomplished in so many different ways. Quoting Hathaway v. Bornman, 137 Con. 322, 324, 77 A2D 91, 93 1950. The 9 elements of common law fraud in the United States. The statutes generally identifies 9 elements needed to establish fraud. 1. A representation of fact. 2. Its falsity. 3. Its materiality. 4. The representer's knowledge of its falsity or ignorance of its truth. 5. The representer's intent that it should be acted upon by the person in the manner reasonably contemplated. 6. The injured party's ignorance of its falsity. 7. The injured party's reliance on its truth. 8. The injured party's right to rely thereon. And 9. The injured party's consequent and proximate injury. See, for example, Strategic Diversity, Incorporated v. Alchemex Corporation, 666 F3D 1197, 1210 N3, 2012 U.S. App. Lexus 1175, at 25 N3 9th Circle, 2012, quoting Staheli v. Kaufman, 122 errors. 380, 383, 595 pages 2D 172, 175 1979. Rice v. McAllister, 268 or 125, 128, 519 pages 2D 1263, 1265 1975. Heitman v. Brown GRP, Incorporated, 638 SW2D 316, 319, 1982 Mo. App. Lexus 3159, at 4 Mo. CT App. 1982. Prince v. Bear River Mutt. Inns. Colorado, 2002, UT 68, paragraph 41, 56 pages 3D 524, 536-37 Utah, 2002. To successfully allege a claim for fraud, a plaintiff must plead each element with specificity and particularity. See, for example, Barron v. Pfizer, Incorporated, 820 NYS 2D 841, 12 MISC. 3D 1169 ANY App. Div. 2006, holding that New York law requires a cause of action for fraud be pled with greater specificity than other causes of action, citing Small v. Lorillard Tobacco Company, 94 NY 2D 43, 57, 720 NE 2D 892, 898 NY 1999. Enyart v. Transamerica Inns. Co., 195 errors. 71, 77, 985 pages 2D 556, 562 errors. CT App. 1998, each element of fraud must be supported by sufficient evidence. Fraud may never be established by doubtful, vague, speculative, or inconclusive evidence. Quoting Eccles v. Beauty Built Homes, Incorporated, 132 errors. 498, 500, 647 pages 2D 629, 631 1982. Linegar v. Sonnenblick, 532 pages 2D 538, 539-40, 23 errors. App. 266, 267-68 errors. CT app. 1975, actionable fraud cannot exist without a concurrence of all essential elements. Citing Nielsen v. Flashberg, 101 errors. 335, 339, 419 pages 2D 514, 518 1966. But C. Zimmerman v. Luce, 162 80, 87-88, 425 pages 2D 803, 807 1967, concluding that fraud may be inferred from circumstantial evidence and that direct proof of reliance is unnecessary to prevail on a common law fraud claim. But C. Dienbo v. Badger, 503 pages 2D 384, 386, 18 errors. App. 426, 428 errors. CT app. 1972, reasoning that a party need not allege with particularity whether the party had a right to rely on representations, because this element is determined from the very facts alleged, citing Jameson v. S. States Life Ins. Co. 412 pages 2D 306, 3 errors. App. 131 1966. Notably, conclusory language will not satisfy the specificity requirement of a common law fraud claim. Small v. Fritz Koss, Incorporated, 30 calories 4th 167, 184, 65 pages 3D 1255, 1265 cal. 2003. C. Armed Forces Ins. EXCH. V. Harrison, 2003 UT 14, 16, 70 pages 3D 35, 40 Utah, 2003, stressing that conclusory allegations in a pleading, unsupported by a recitation of relevant surrounding facts, are insufficient to preclude summary judgment. The Federal Rules of Civil Procedure at Rule No. 37 highlights the need of a party to respond when required and necessary information is sought, and this being of necessity without court order respecting a legal process. Rule 37. Failure to make disclosures or to cooperate in discovery. Sanctions primary tabs. B. To compel a discovery response. A party seeking discovery may move for an order compelling an answer, designation, production, or inspection. This motion may be made if, i.e. deponent fails to answer a question asked under Rule 30 or 31. E. A corporation or other entity fails to make a designation under Rule 30b, 6, or 31a4. E. A party fails to answer an interrogatory submitted under Rule 33. Or if a party fails to produce documents or fails to respond that inspection will be permitted or fails to permit inspection as requested under Rule 34. C. Related to a deposition. When taking an oral deposition, the party asking a question may complete or adjourn the examination before moving for an order. 4. Evasive or incomplete disclosure, answer, or response. For purposes of this subdivision A, an evasive or incomplete disclosure, answer, or response must be treated as a failure to disclose, answer, or respond. As has been noted, the Federal Arbitration Act includes an arbitration process, should the arbitrator determine that you and your organization and the undersigned had a prior relationship, and that relationship involved a debt. You may be required by said arbitrator to show cause for your lack of response. Under the United States Code Service, and the Federal Fair Debt Collections Act, codified in part at 15 U.S. Code Section 1692G, validation of debts, notice of debt. Contents within 5 days after the initial communication with the consumer in connection with the collection of any debt, a debt collector shall, unless the following information is contained in the initial communication or the consumer has paid the debt, send the consumer a written notice containing 1. The amount of the debt. 2. The name of the creditor to whom the debt is owed. 3. A statement that unless the consumer, within 30 days after receipt of the notice, disputes the validity of the debt, or any portion thereof, the debt will be assumed to be valid by the debt collector. 4. A statement that if the consumer notifies the debt collector in writing within the 30-day period that the debt, or any portion thereof, is disputed, the debt collector will obtain verification of the debt or a copy of a judgment against the consumer, and a copy of such verification or judgment will be mailed to the consumer by the debt collector. And B. Disputed debts. A. That the debt, or any portion thereof, is disputed, or that the consumer requests the name and address of the original creditor, the debt collector shall cease collection of the debt. or any disputed portion thereof, until the debt collector obtains verification of the debt or a copy of a judgment, or the name and address of the original creditor, and a copy of such verification or judgment, or name and address of the original creditor, is mailed to the consumer by the debt collector. A. Unless the consumer has notified the debt collector in writing that the debt, or any portion of the debt, is disputed, or that the consumer requests the name and address of the original creditor. Pub. L 90-321, Title VIII, Section 09, as added. Pub. L 95-109, September 20, 1977, 91 Stat. 879. Amended. Pub. L 109-351, Title VIII, Section 02, October 13, 2006, 120 Stat. 2006. Initial communication is defined as follows. The lack of a statutory definition for initial communication means that courts are free to interpret what will qualify, leaving debt collection firms to make their own determinations as to what will sufficiently protect them from later lawsuits. We are all in agreement of the following. If a contract requires extensive changes, it's generally wiser to create an entirely new agreement, or, alternatively, to create an amendment and restatement, an agreement in which the prior contract is reproduced with the changes included. You and/or members of your organization have changed the terms and conditions of our original agreement. By your changing the terms of our agreement in recent days, I have under the law the right to conditionally accept your agreement on their specific terms and conditions, and such does not necessitate the need for signatures. For instance, every citizen of the United States and every citizen of each of the separate states of the United States have a contractual relationship with the other. In reference to the United States and/or the states, they have the obligation to redress to correct the wrongs, the grade-level complaints of their constituents, thus establishing not only a prior relationship but also the doer's duty to respond and/or perform. We hold these truths to be self-evident, that the right to contract is absolute, and to notify all parties that the ignoring of one party and/or their communication when there is a duty to respond is a violation of this agreement with respect to the parties and their communications in dealing with each other. 10,012. Notice, all titles, names, appellations of corporate government juridical constructs, and branches, departments, agencies, bureaus, offices, sub-whatevers, and the like thereof, include any and all derivatives and variations in the spelling of said titles, names, appellations. 10,013. Notice, any and all attempts at providing the requested and necessary proof of claims raised herein above, and requesting the additional 10 calendar days from the date of which this agreement is placed online, and any reference to 10 calendar days shall be referencing 10 calendar days from the date of this posting of March 7, 2019, and no later, in which to provide same, and to address any and all questions and concerns to the undersigned in regards to the stated copyright and waiver herein expressed, in any manner other than that provided for herein, will be deemed non-responsive. 49,253. The undersigned and/or their associates and/or their heirs and/or their assigns extends to the respondent S. the undersigned's appreciations and thanks for respondent's S. prompt attention, response, production of above proof S. of claim and assistance in these matter S. This presentment is not to be construed as an acceptance and/or application and/or subscription and/or request for license, admittance to any jurisdiction quasi or otherwise, but shall remain as a direct objection to any and all claims to the contrary. Truly honored to be in agreement. /S/ the Securities Acquisition Trust Commission, a private foundational trust organization, WSEFH 7-3YEN1-5SD5FSDLHGSAU EGTF 1-6EEON. Copyright is secured and reserved with all rights retained. Private property, no trespass permitted or allowed under common law restrictions and prohibitions. March 12, 2021. S/Setcom and the EEON Foundation. The remainder of this agreement is intentionally left blank, located here. https Setcom 911com terms HTML.
That was a whole lot of information. Ladies and gentlemen, as you can see, we amended the document since 2018. The last time it was done was March 2012. For any and all organizations and/or companies, this will constitute notice. So this is our notice that we are changing terms and conditions. However, if you've already received this notice, then there are no changes to the terms and conditions. That's what you need to do. You need to put a statement within your agreement that if they've received the notification prior, that any subsequent receipt, as is the case here, does not alter and or change and or renew the agreement, but the agreement continues as agreed, and that there will be, cannot be, and the parties agree to no amending of these terms and conditions. Just that simple. Because your plan is not to amend the terms and conditions, with the exception of clerical errors and or ambiguities, which shall not have a bearing or an and or direct effect on the validity of the contract, nor shall it substantially deplete the validity, value, and obligations under the terms of the agreement. You see how I did that? That's what we incorporate into this agreement. And we place this agreement online in this fashion to protect the company, protect the people. Now, we'll be doing a video in the future. We'll be talking about SAA and why SAA is so unique in organizations, how there is not another one like it. Many have tried to be like SAA, and they've all gone out of business. Many have tried to do what SAA is doing, and they've all gone out of business. Why? Because the courts have ran them out of business. Why? Because they are a threat to the status quo, a threat to their contracting with you and then binding you to those contracts. So let's start cutting away at those contracts. Let's start. Gotta go, ladies and gentlemen. Y'all take care. Speak to you later. Arrivederci. Adios. Sayonara. Goodbye.